when we looked out, or the judge and I looked out into the ether of Westlaw, there was nothing that we could find, and the parties certainly weren't citing to any precedent that would tell us what reasonable or a reasonable rate meant within the RAND context. So as a result, you're kind of grasping at straws, trying to find how to define the word reasonable within this context of RAND, which was a context that I don't think had been litigated fully throughout any district court ever. And so, yes, you do grasp, the word reasonable is inherent in, I think, law. It's inherent in tort law. It's inherent in contract law, where parties agree to act reasonably. So we did look to precedent. There's a lot of precedent in patent law in terms of a royalty in an infringement setting, where you get a reasonable royalty that would be negotiated. And that's helpful because here you have patents. They just happen to be standard essential patents, and they are still patents, and they're going to be licensed to somebody at what amounts to a reasonable royalty. And it's just figuring out how to apply that word reasonable within the overarching context of the RAND commitments and RAND obligations and where they come from and why they're there. The Georgia-Pacific factors are a natural analogy to this case in the sense that it's how two parties in determining damages traditionally, or one of the very well adopted methods for determining what a royalty will be paid for the infringement of a patent. And they've long been applied, and their precedent is strong in the patent community. So I think that gave at least myself, but I'm guessing the judge, some level of comfort in knowing that here are 15 factors that courts, including the Federal Circuit, have somewhat blessed through the years that can help us figure out what two people would do to figure out what the term reasonable meant within a different patent context, one where there's a monopoly over the patent versus in the RAND context, where there isn't. But at least it gives you a framework for setting up how to do this and come to an answer for the word reasonable. So yes, the Georgia-Pacific factors were something that provided precedent and comfort in a way that we felt would be, or at least the judge, I believe, felt would be well grounded in the law, in the history of the law.